Mr. Chief Justice, and may it please the Court, my name is Attorney Morris, and I represent the respondent, the State of Olympus. The respondent respectfully requests that this Court affirm the decision of the trial court because Mr. Bronner's Fourth Amendment rights were not violated by the police obtaining his cell phone records. There was no search in this case, and even if this Court were to rule that a search did occur, the exigent circumstances of the situation made the need for law enforcement so compelling to be able to dispense with the warrant requirement. As petitioner correctly stated in Katz v. United States, the Supreme Court defined a search as any governmental intrusion upon a person's objective and subjective expectation of privacy. So, as the petitioner stated, that in order for a search to occur, the officers in this case would have to had actually intruded on Bronner's expectation of privacy, and also one that society was willing to recognize as reasonable. The petitioner states Carpenter v. United States, where the Supreme Court rules on cell site location information. The Supreme Court rules that the agents in that case obtaining of Carpenter's cell site location information for over a period of 108 days constituted a search. It constituted a search because in that case, the officers tracked his phone within a 2-mile radius of any time for over those 108 days. It was historical cell site location information. The distinguishing element in our case is that our case presents real-time cell site location information. The petitioner states that any obtainment of cell site location information will be deemed a search. However, that is untrue, as Carpenter specifically left open for future discussion that if real-time cell site location information is held to the same standard as historical cell site location information. The respondent argued that it does not because real-time cell site location information is less intrusive than actually chronicling a person's movements with over an extended period. This is not the case in our situation because the agent in our case only tracked when Mr. Bronner's cell phone was within 5 miles of 10 specific addresses and recorded the phone numbers that he communicated with when his phone was within 10 miles of 10 specific addresses. The likelihood of them bumping into Bronner and actually searching where he was highly unreasonable because there are multiple businesses and establishments that Mr. Bronner could have been at those times. The petitioner also cites United States v. Jones and says that searches have to be held to a certain scrutiny as discussed in the concurring opinion. However, because it was a concurring opinion, it isn't binding. It may be persuasive, but it isn't binding. The important part of United States v. Jones is that the Supreme Court ruled that the attachment of a GPS device on a person's cell phone or physical property, a person's physical property constituted a search. In this case, however, there was no physical attachment of any device on Mr. Bronner's physical property. The cell site location information was obtained by Olympus Cellular Towers, and the agents in that case neither had to attach anything to those towers or manipulate Mr. Bronner's physical property in any way to gather this information. Also, the petitioner cites Kylo v. United States and says that information that is common knowledge and that is not within public use may be considered a search. However, this is also not the case in the case at bar because Kylo also says that if agent of the government uses sense enhancing technology to discover something that they would not have been able to discover without being physically present at that scene, then that would constitute a search. However, in Kylo, they ruled that there was a search because they searched inside Mr. Kylo's home. There is no search inside Mr. Bronner's home, so the expectation of privacy is lessened by that regard, and also the agents did not use sense enhancing technology that was outside of the public's general use. What they did was track his cell site location information and his the phone number that he communicated with when his phone was within 5 to 10 miles of 10 specific addresses. These addresses were public locations that were gathered by an informant. Page 3 on the record shows that the agents obtained this information by a willing informant. Also, there is the argument that whatever a person willingly shares with a third party, he or she no longer maintains an expectation of privacy in those records. This is the case at hand. Mr. Bronner is a cell phone user with Olympus State University, so Olympus Cellular. So he understands that there are certain things that he must give up to receive service, because the recording of cell site location information is actually an important business purpose for Olympus Cellular to provide service to their customers. And Mr. Bronner has acknowledged of this. So the argument that his sharing of information was unwilling or without his conscious assent cannot be applied to this case as it was in Carpenter v. Jones. Carpenter v. United States. Excuse me. The petitioner also cites Riley v. California and says that a person retains an expectation of privacy in the movements of his cell phone. This is true. However, the context in Riley and the context at the case at bar are two different contexts and cannot be considered on the same principle. Riley discussed that an agent, when reasonable to do so, should obtain a warrant to search the digital data is stored on a person's phone. The police did not obtain records to search the digital data on the person's phone. However, they didn't even get close to searching Bronner's text message, pictures, and videos as the one seen in Riley v. California. What they did obtain was a vague location information of where Mr. Bronner could have been when his phone was within a 5-mile or 10-mile radius of those specific addresses. And because he willingly shared it, as the third-party doctrine makes clear, Mr. Bronner did not maintain an expectation of privacy and no cell phone records. Moving on to my second point, if this court were to rule that a search did occur, there were exigent circumstances to make the warrantless search reasonable. As petitioner cited, Missouri v. McNeely discusses that when we are viewing exigency, we should look at the totality of the circumstances. Missouri also enumerates the three possibilities when exigent circumstances can occur in hot pursuit. The suspects in this case were known to be traveling to Vegas in a short while. The emergency aid, because human trafficking is such a huge problem for the community and the persons involved, there's always a need to provide emergency, because statistically speaking, as page 2, footnote 2 states that at any time 2.4 million people are caught in human trafficking situations, and destruction of evidence because there was strong evidence to believe that Mr. Bronner would be leaving. Um, any evidence that the agents in this case, um, any evidence that the agents in this case could have obtained would have left with Mr. Bronner and the destruction of his cell phone. So the totality of the circumstances, even though there may not have been a present moment exigency as the petitioner says, the totality of the circumstances, and because there are all three exigent circumstances that are present, makes the warrantless search reasonable. And lastly, in Kentucky v. King, the court recognizes that police agents are often forced to make split-second decisions, and because of this, they made clear that a police officer does not have to call halt to a criminal investigation as soon as probable cause arises. He or she may continue his search, and that is what the officers in this case did. For the reasons stated above, the respondent respectfully requests that this court affirm the decisions of the trial court. Thank you.